Hi there and welcome. In this knowledge clip, I'm going to talk to you about corporate finance, about a paper by Porta, Lopez de Silanes, Schleifer, and Vishny on the different ways that firms can finance their businesses. Firms have different means available to finance their activities. First, they can seek credit. If you lend money to a firm, you are entitled to an interest payment. And perhaps if the firm would default on its obligations, you would have the right to repossess the collateral, so the item that was bought with the money that you lent to the firm. Firms can also opt for equity funding. And that is, investors buy shares in the company. They become owners of the company and they are entitled to the residual income, that money that is left to when all the other obligations are paid off, including the debt holders. Now, in contrast to equity payments, debt payments have a fixed interest rate, so they have a fixed payment. You know the return that you will have. And in exchange for the security, the rights that you have are fairly limited. In contrast, equity owners have an unknown return. They may have expectations, but what will be left at the end of the day is unknown. And hence, they have a stronger say in the decision making of the firm. Now, countries can help debt holders as well as owners, equity holders, when they want to exercise the rights that they have through the legislation that is available to them. And the LLSV paper, as it is referred to, asked whether countries differentially go about the regulations for debt holders and shareholders. Are some countries more involved in developing shareholder rights than creditor rights? Are some countries more involved in enforcing these rights, etc.? So these are the questions that I will go into one after the other. The distinction that they make is that between common and civil law countries. Common law countries are characterized by active markets for corporate control, so there's a lot of trading of ownership going on. Financing is mostly through equity, and labor markets tend to be flexible. Civil law countries, in contrast, tend to be characterized by debt financing. They have fairly inflexible labor markets, and the market for corporate control is relatively underdeveloped. And the paper wonders whether countries that have a common law tradition have different types of regulations for shareholders as compared to creditors than countries that have a civil law tradition. These civil law countries are then further subdivided depending on the origin of the legislation into German civil law countries, Scandinavian civil law countries, and French civil law countries. The first question that the paper asks is whether countries that have strong creditor rights have weak equity rights. You may wonder whether it makes sense for a country to specialize in both. After all, firms could have either debt or equity financing. In this graph, what you see is the shareholder rights on the one axis and the creditor rights on the other. Now, if all countries would either specialize in creditor rights or in shareholder rights, you would see a lot of countries in the lower right and upper left corners of this graph. In contrast, we see that common law countries are located in the upper right corner. So common law countries have strong creditor rights as well as strong equity rights. In contrast, French origin civil law countries, they tend to have low rights of both kinds. So shareholders are weakly protected, but the same applies to creditors. So the first question, whether the countries specialize in one or the other field, that apparently is not the case. Countries are, if you think of English origin countries, either specialized in both creditor and shareholder rights or in neither of the two. The follow-up question that the paper then asks is whether countries that have weak rights then compensate for these weak rights with strong enforcement of these rights. After all, you may have weak rights, so there's not an awful lot that you can demand from the company, but if you think that you don't get what you're entitled to, then at least enforcement of these rights might be strong. So a shareholder or the debt holder may be better off with strongly enforced weak rights than with weakly enforced strong rights. The second graph shows on the horizontal axis the rights, which is the shareholder and the creditor rights collapsed into one measure because they more or less go hand in hand, as we saw before. So that's what we find on the horizontal axis. On the vertical axis, we find an indicator of enforcement. The paper has multiple indicators of enforcement, but they pretty much boil down to the same conclusion. We see a couple of things happening. First, we see that Scandinavian countries, and to a lesser extent German origin countries, that they have fairly strong enforcement of their relatively weak rules. And so here indeed we see that for Scandinavian and to a lesser extent German civil law countries, there is a compensation for weaker rules by stronger enforcement of these rules. In the UK and the US and other common law countries, strong rules are generally strong enforced. In French countries, we see, and they are below the arc, we already saw that they have weak rights. And now on top of this, we see that they also generally have weak enforcement of these weak rights. This pretty much implies that investors, whether they are creditors or shareholders in French civil law countries, have fairly little to ask from companies, and they can't go to court to exercise these rights either. At least they can, but they're not as sure that they get what they're entitled to as their counterparts in the US, the UK, Germany, or Scandinavia, or their descendants. So what happens then? How do businesses get funded in these countries? What we see is, and this is the third graph, which again has the rights indicator on the horizontal axis, but then on the vertical axis, the concentration of ownership. So the size of the shares owned by the largest owners of a company. And there we see that all the French origin countries end up high in this graph. So these, what happens in these markets is that investors cannot rely too strongly on the governments for the rights that they need. They cannot rely too strongly on the courts either to enforce these rights. So what they do, they build up large chunks of ownership, or they extend large chunks of credit to the companies, such that they at least have a strong say in the company itself, outside the possibility to enforce your rights externally, so outside the walls of the firm. Investors rely on their decision-making power within the firm.